Good morning. X against Kuoni Travel Limited concerns the obligations owed to consumers by companies which organize package holidays. I should explain that the court has ordered that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of her family in connection with these proceedings. On or about the 1st of April 2010, the appellant, Mrs. X, and her husband entered into a contract with the respondent tour operator, Kuoni. The contract was for a package holiday in Sri Lanka. It included return flights from the United Kingdom, as well as 15 nights all-inclusive accommodation at a 4-star hotel between the 8th and the 23rd of July 2010. In the early hours of the 17th of July 2010, Mrs. X was making her way through the grounds of the hotel when she came upon N. N was employed by the hotel as an electrician and was known to Mrs. X as such. Under the pretense of showing her a shortcut to reception, N lured Mrs. X into the engineering room where he raped and assaulted her. Mrs. X brought a claim for damages against Kuoni. She claimed that the rape and assault were a breach of contract and/or gave rise to liability under the Travel, Package Holidays and Package Tours Regulations 1992. The High Court dismissed Mrs. X's claim. The Court of Appeal then dismissed her appeal. Mrs. X now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal. The first question for the court to consider is whether the rape and assault of Mrs. X amounted to an improper performance of the contractual obligations owed by Kuoni. The court's answer to that question is yes. In its judgment, the court takes a broad view of the obligations owed by tour operators to consumers under package holiday contracts. Those obligations include not only the provision of transport, accommodation, and meals, but also a range of ancillary services which are necessary for the provision of a holiday of a reasonable standard. In the present case, Kuoni undertook to provide a package holiday at a 4-star hotel. It is an integral part of a holiday of such a standard that hotel staff provide guests with assistance with ordinary matters affecting them at the hotel as part of their holiday experience. This includes guiding guests from one part of the hotel to another. In the present case, the rape and assault of Mrs. X amounted to a failure to provide that service with proper care. Kuoni has therefore breached its obligations under its contract with Mrs. X. Regulation 15.2 of the 1992 regulations also imposes liability on Kuoni for damage caused to Mrs. X by its improper performance of the contract. The second question for the court to consider is whether Kuoni has a defense to Mrs. X's claim under Regulation 15.2c of the 1992 regulations and/or Clause 510b of the contract. The court's answer to that question is no. Regulation 15.2c of the 1992 regulations would provide Kuoni with a defense if the rape and assault were events which, even with all due care, Kuoni could not have foreseen or forestalled. This defense is replicated in Clause 510b of the contract and itself replicates the defense in Article 5 of the EU Directive on package travel, package holidays, and package tours. At the hearing of the appeal, the Supreme Court decided to refer certain questions concerning the interpretation of Article 5 of the Directive to the Court of Justice of the European Union. The Court of Justice answered the Supreme Court's questions in a judgment delivered on the 18th of March 2021. In its judgment, the Court of Justice took a narrow view of the defence in Article 5.2 of the Directive, decided that the defence does not apply where the improper performance of obligations under a package holiday contract is the result of acts or omissions of employees of suppliers of services performing those obligations. Court of Justice's decision is binding on this court. On that basis, the Supreme Court decides that Kuoni does not have a defence to Mrs. X's claim under Clause 510B of the contract or under Regulation 15.2c of the 1992 regulations. This is because the rape and assault were committed by an employee of another supplier of services, namely the hotel. For these reasons, the Supreme Court allows the appeal. Kuoni is liable to Mrs. X both for breach of contract and under the 1992 regulations.